I'd like to begin by celebrating and paying my respects to the Ngunnawal and Ngambri peoples, their elders and ancestors, the traditional custodians of the land on which we meet today. My name is Toni Erskine, and I'm a professor of international politics in the International Relations Department here in the Coral Bell School of Asia-Pacific Affairs. Welcome to the 8th seminar in our Discussing AI, Automated Systems, and the Future of War seminar series. Now, this seminar series is part of a 2.5-year project on anticipating the future of war, AI, automated systems, and resort to force decision-making. And it's been generously funded by the Australian government through a grant by Defence. What we've done in this project is to address both the risks and the opportunities of using AI in resort to force decision-making, so on decisions at the state level to wage war. And the motivation behind the project was really to address a neglected area where there had been a lot of focus on how AI-enabled systems were used in the conduct of war, for example, in lethal autonomous weapon systems. But there hadn't been attention paid to how AI could, perhaps in the future, be used in decisions to actually go to war. So that was the premise of the project. When I wrote the proposal for the project back in about 2021, people said, oh, that's interesting, but is that really something that is going to happen? And now when we're experiencing the debate between, or the battle, I should say, between Anthropic and the Pentagon on the use of Anthropic's AI models, when we're having reports that actually Anthropic's Claude was in fact used in strategic decision-making in the attack on Iran, we see that this speculation a few years ago is something that is actually happening right now and happening more quickly than I even anticipated. So the immediate relevance of this topic, I think, is very apparent. I'm really pleased to have Dr. Sarah Logan, who's been involved in the project since its inception, and this is actually the second outstanding research paper that she's written as part of the project. I'm delighted to have her here presenting in the seminar today. I'm also really happy to announce that our second edited collection was just published about a month ago. It's in the Cambridge Forum of AI, Law and Governance, AI, and the Decision to Go to War. It's edited by me and Steve Miller, who's at Harvard. And the paper that Sarah is going to tell us about today is one of the papers that is just being published in this special issue. Now, Dr. Logan is senior lecturer in the Department of International Relations in the Coral Bell School of Asia-Pacific Affairs. Before she joined academia, she worked in intelligence analysis for the Australian government. Her research interests focus on the impact of information technology on international politics, and her current projects include a study of the relationship between information and political authority and an assessment of the impact of big tech on state capacities to exercise control over political violence. Her outstanding single-authored monograph, Hold Your Friends Close, Countering Radicalization in Britain and America, was published by Oxford University Press in 2024. The title of Dr. Logan's talk today is Certainty and Algorithmic Accountability in the Decision to Go to War, Lessons from Evidentiary Approaches to in International Criminal Law. There are copies of her paper and other papers from the special issue at the back, which you're welcome to help yourselves to at the end of this session. I'm now going to turn things over to Dr. Logan. Sarah, it's wonderful to have you as part of the project, and I'm really looking forward to your talk. Over to you.
Great. Thank you, Toni. Hello, everyone, and thank you for coming today. I'd like to begin by going straight back to Toni and thanking Professor Toni Erskine for the opportunity to present today. This research is part of a wonderful project. Professor Erskine was awarded a Defence Strategic Policy Grant in 2023 to research the use of AI in the decisions to go to war, and it's been a privilege to be part of the research community about this project, which, as Professor Erskine mentioned, is feeling increasingly and troublingly relevant. So today I'll be discussing the role of certainty and accountability in the use of AI in decisions to resort to force. I'll begin by briefly introducing the problem of certainty and accountability in AI more generally, by opening with a discussion of the concept of accountable AI. And then I'll go to a discussion focusing on debates around accountable AI and the decision to go to war. So I'll be arguing that ultimately these debates hold that AI can only produce accountability if it can produce certainty about what has occurred in the past, about what decisions were made and how. And that in this argument, this certainty can only be achieved by increasing the transparency of AI decision-making. This all feels quite obvious, but I think it's important to kind of drill down into what we actually mean when we talk about accountable AI. I'll then move to argue that an emphasis on certainty underlies the discussions of AI accountability and the promise of accountable AI, and that the push for certainty is socially constructed in ways which should be unpacked if we want to understand exactly what we are asking accountable AI to do and why. And I'll get to that point by introducing the concept of documentality and looking at ways that certainty and accountability in Western bureaucratic cultures rely on the production of documents. And this, I argue, this production of documents and ideas around it underlie our search for accountable AI and our emphasis on transparency, which in practice means the production of documents about decision-making in a very familiar and predictable forms. Unfortunately, though, AI does not produce documents in the way we want it to, and so I argue we're inevitably left wanting because the model of accountability that we're requiring AI to adopt is a socially constructed one rather than the only model available, and indeed one that is not really technologically or technically feasible. And then I'll argue that there are other ways to get acceptable levels of certainty about uncertain events. There are other models of accountability which don't rely on documentation in the same way. In fact, we use these models of accountability all the time, especially in high-stakes decision-making, which is in many ways similar to the decision to resort to force. And what I'll be doing is taking international criminal law as an example of these other ways that we produce accountability without certainty, without documents. And in particular, I'll be looking at the case of the International Criminal Tribunal for the former Yugoslavia, so the ICTY. I'll outline briefly the way the ICTY dealt with the problem of uncertainty and the absence of documentation in the context of two new scientific technologies and forms of evidence. So forensic DNA evidence and satellite imagery. And then I'll round the discussion off with a sketch of what that process of establishing certainty at the ICTY might offer us in terms of opening up a discussion about the establishment of certainty without documents and why that is important in the context of accountable AI. So in this slide, I'll attempt to quickly outline why scholars and practitioners alike are concerned about the problem of accountable AI in the resort to force. This image is a picture of a girls' elementary school in Manib, Iran. Approximately 160 young girls died in this attack, which was allegedly the result of a US Tomahawk missile strike on the 28th of February this year, the first day of the current conflict in the Gulf. The missile struck within the first cluster of attacks, which lasted about 30 minutes, the same cluster of attacks which killed Ayatollah Khomeini. And depending on who you ask, these strikes might amount together as an indication of a decision to resort to force. It's certainly more than a simple exercise in targeting. Importantly, US Tomahawk missiles are likely to be using an AI-enabled targeting system, and investigations by the New York Times and Human Rights Watch reveal that the girls' school which was destroyed, this image here, sits on the site of a compound which was attached to the Iranian Revolutionary Guard Corps, the IRGC, about 10 years ago. And these investigations suggest that it's possible that the strike was delivered by an AI-enabled system which used faulty or outdated location data to the IRGC. The system thought it was targeting Iran's military leadership when in fact it was targeting a girls' school. And again, this is more than a simple targeting exercise. It's part of a complex set of decision-making procedures which led to strikes in broad daylight aimed at decapitating the Iranian leadership and initiating a serious conflict. Again, accountable AI means being able to identify how a decision like this might have been made. Before we can hold something or someone responsible, we must know what has occurred. The problem is that with increasingly complex AI systems, we simply cannot know. The systems are now so complex that even if we wanted to, even if the Pentagon allowed journalists inside their systems, for example, there'd be no way of digging into the neural networks involved in sophisticated generative AI systems to find out what happened, to find out how decisions were made, and so to apportion responsibility. The accountable AI which dominates the discourse today seeks to remedy this problem, which we can also call the black box problem. It's a fairly familiar one in debates about AI. The problem of not knowing what happened and so not knowing who to hold accountable. The accountable AI debates today focus on demanding increasing transparency in AI design. So as a way to sort of remedy this problem to get at it. We might not know exactly what happened, but there are things that we can know. And the ultimate goal is transparency. You can see the beginnings of this move in the way driverless cars are regulated in some states in the US. So some states now will require driverless cars to log second-by-second data inputs. So what did it see at this point? What did it see at this point? What did it see at this point? It's not a record of the decision, but it's a record of the data that was inputted into the decision. So that shows us when a decision might have occurred, if not entirely how. So other measures might focus on requiring engineers and designers to show how different elements of the data AI models use are weighted so that we can see the elements of the decision-making, if not the decision itself. So both of these approaches and the field of accountable AI more broadly inherently rely on the concept of transparency about what has occurred in the decision-making process. That transparency about what has occurred is used as a way to establish certainty about what has occurred, and that is then used as the basis for accountability for what has occurred. So it goes like this: transparency, certainty, accountability. And this is what we call a decompositional model of AI accountability, and that's what dominates the discourse at the moment. The problem is, though, as I've already alluded to, that decisions made by complex AI systems are not transparent. The technology to access them does not exist, and according to some cannot exist because of the complexity of the models involved, because of the way they work. This is the infamous black box problem. This means that at the moment, the field of accountable AI is doomed to sort of march in circles because it's demanding transparency that is not technically possible, and it becomes essentially a technocratic argument and a technocratic debate. So I wanted to move now to a discussion of why it is that accountable AI, this decompositional model, and much of Western society focuses on transparency as the route to certainty. Why is it that we assume that if we can only see what is going on, then we can be certain about how decisions are made and then enforce accountability effectively? This seems like a holy grail in accountable AI, but why do we think this? The literature on accountability and transparency is remarkably ill-defined, especially in the context of accountable AI. The terms accountability and transparency are often taken for granted or used interchangeably. What is clear, though, is that the link between transparency, certainty about what has occurred, and accountability is a relatively new idea and not something which exists as a given. This is not an idea that comes out in the accountable AI debates. Instead, you'll find it in the sociology of bureaucracy, for example, or in information science or library science. This is not the only way to think about accountability, but it is the primary way that we do, and it infuses and underpins the arguments for accountable AI. So the link between transparency, certainty, and accountability that you find in these debates around decompositional AI is bound up on ideas about the knowability of the social world, which emerged in the 19th century. Prior to that, and speaking as a citizen of the West here, as a white woman, we didn't expect that transparency would lead to certainty, or that if we were certain about what had occurred, we would be able to apportion accountability in a way that made sense. It's important to note, for example, that today the discussion about accountable AI is very much centred in the global north, and it's linked to ideals about democratic accountability and the proper function of democracies. No one's having these arguments in China or Russia. Accountability is socially constructed, and it doesn't have to look the way it does for us in the discourse around accountable AI. There's an important term from library and information sciences that I'm relying on here to make my argument, linking accountable AI and the social construction of accountability. So that term is documentality. The literature on documentality shows that the link between transparency and accountability in the West, in systems like ours, turns on the production of documents, which provide certainty about what has occurred in the past. In Western democratic cultures, documents are produced at the point at which a decision is made by those involved, allowing us to be certain about what has occurred and thus know who to blame for it. So I imagine that at least some of you here today are public servants, so I wanted to use bureaucracies as an example of this concept. The image you see here is Max Weber, the famous sociologist of bureaucracy, and he argued that the ideal form of bureaucracies relied on systematic record keeping, indeed on the production of documents. He's not using the term documentality, but that is what he's talking about. So systematic record keeping for Weber, the production of documents, is the basis for establishing proper authority. If any of you have ever had to take minutes of a meeting or to produce a cabinet memo, you'll know exactly what I'm talking about. Documents are the way that decisions are made transparent, the way that we can be certain about what has occurred, when a decision is made, how it was made, And transparency, for those of us in Western democratic and bureaucratic traditions, is the route to accountability. That's how we know who to blame, right? The problem is that AI does not produce documents. We ask it to and it does not provide them. There's no minutes of the meetings which are held to produce a decision. There's no archives, no paper trail. So why are we searching for documents which do not exist and which cannot exist when we try to make AI decision-making accountable? Why is accountable AI obsessed with documents? Is there another way? And that's what I'm trying to think through here. So my argument is that we often enforce accountability in situations where there are no documents telling us exactly what happened and who is responsible, where there is no transparency, there is no paper trail. We already do this. And we do this in high-stakes international arenas, which are not dissimilar to this decision to resort to force. So what can we learn from these cases and how can we apply those lessons to accountable AI? In an effort to flesh out this argument, I've adopted international criminal law as an exploratory case study, and in particular the case of the International Criminal Tribunal for the former Yugoslavia, which was the first international war crimes tribunal since the Nuremberg and Tokyo trials at the end of World War II. So I've done this for two reasons. The first is that international criminal law, and in fact all criminal law, relies on rules of evidence that give an appropriate level of certainty about what has occurred, an acceptable level of certainty, but in the absence of documents which tell us that. So, for example, if I want to find out who was responsible for a massacre, I can't just get a printout of what occurred from inside the mind of the person who did it. There is no document. I have to arrive at certainty about what has occurred via rules of evidence and via a process of weighing up different types of evidence and a range of moral and ethical concepts. And I have to apportion responsibility, accountability, based on those processes rather than on documents. The ICTY was the first tribunal of its kind, and it's important because it wasn't relying on established evidence law in this process of establishing certainty about what had occurred and apportioning responsibility. The ICTY rules of evidence represent the first attempt to create a coherent and credible code of procedure and evidence for the prosecution of international criminal conduct, and particularly the prosecution of violations of international humanitarian law. And I was doing this in a high-stakes environment, which, as I said, is usefully similar to the environment in which resort to force decisions are made. So the second reason I've adopted the ICTY as a case study is that it also engaged with two technologies which we knew at the time. You have this same argument about complexity and technical, the evolution of kind of increasingly complex technical tools. So for the first time in international criminal law, the ICTY had to deal with forensic DNA evidence and satellite imagery. These were two new technologies at the time. And as the judgment was produced, you can see the way that the ICTY judgments, the way the judges arrive at the decision to apportion responsibility for crimes against humanity, not only without having absolute certainty about what has occurred, but without having a deep understanding of how these new complex technologies worked. So it's very similar to the problem of AI in lots of important ways. But in the context of the ICTY, accountability was enforced in the absence of absolute documentary certainty about what had occurred and how decisions to commit crimes were made. So there was no kind of Gollum-like spool of information coming out of Milosevic's mouth as he took the stand. The rules of evidence had to stand in for documentary certainty, and in the process, the ICTY provided enough certainty for accountability to be enforced, if not the complete certainty that documentation might have provided. And in the end, enough certainty was provided for accountability to be enforced in the sense that 161 individuals were indicted and 90 individuals were convicted and sentenced for war crimes, crimes against humanity, and genocide. In the next few slides, I'd like to quickly look about how that accountability was arrived at in the ICTY by looking at the treatment of forensic DNA evidence and satellite imagery at the tribunal and drawing some lessons from that experience for debates about accountable AI. So the ICTY saw a shift to the use of new forensic DNA technologies by the prosecution to establish epistemic certainty as to the matter at hand, primarily how many dead, their identities, and the circumstances in which they died. Because judges were not experts in these technologies, this meant allowing expert testimony to facilitate judicial certainty as to what had occurred. Assessment of the certainty afforded by such technologies, including DNA analysis, was contested in cross-examination of expert witnesses, and it was incorporated into judgments for the first time in international law. So, for example, the Kristic trial, the trial one of the defendants, saw one of the first and most significant uses of forensic DNA evidence at this ICTY. Evidence from mass graves corroborated the testimonies of witnesses concerning mass executions and the burial of thousands of Bosnian Muslim men. The forensic evidence in Krstich included reports on exhumations, autopsies, and laboratory analysis, as well as photographic evidence, material artifacts, and DNA evidence pulled from that. It helped to establish that genocide had occurred, and secondly, to establish genocidal intent. Importantly, expert witnesses were called upon to interpret the scientific data for the court, and they played a neutral role rather than appearing as witnesses for either side. Forensic expertise used by prosecutors encompassed various disciplines such as forensic anthropology, archaeology, and pathology, so there's a lot of information feeding into this. And the experts were cross-examined extensively and were called upon to describe and justify the analytic and scientific methods employed in the field. In the end, the judgment in Krstich, which was a guilty judgment, was clear on the role and value of forensic evidence in reducing uncertainty. But this uncertainty was reduced not by documentation, but by corroboration across domains of knowledge production. So it wasn't that one expert was deemed correct. Instead, as the judgment stated, the accounts given by the survivors of the execution sites are corroborated by forensic evidence at some of the execution sites, expert analysis of the contents of mass graves, and aerial reconnaissance photographs taken in 1995. That is, the judgment saw the epistemic value of forensic DNA evidence as corroborative rather than the truth of forensic science itself. And the ICTY also relied on the value of contestation of DNA evidence. This process of contestation drew on familiar adversarial elements of the common law legal structure. And if you ever watch Law and Order, you'll know what I'm talking about. Someone takes a stand, someone interrogates them. Examination in chief by the party calling the witness, cross-examination by opposing parties, and if necessary, re-examination to deal with matters brought out under cross-examination. In the Popovich trial, for example, defence and prosecutors battled over how DNA technology worked and what it actually did. No one agreed, and there was no evidentiary standard for admitting DNA evidence. What they were doing was debating around the black box of the DNA and technology without having to see what was in it. For example, the defence in Popovich challenged the prosecution's forensic evidence, specifically the use of DNA matching to identify victims, by calling witnesses who challenged both the scientific methods employed and the professional credentials of the forensic experts called by the prosecution. In the judgment, the chambers noted that the contestability around DNA evidence had served to strengthen the prosecution's case. It was enough, even though it wasn't absolute certainty. The ICTY also saw satellite imagery used for the first time in international criminal law. This imagery, some of which you can see up on the screen, was provided by the US government and was used by the prosecution. The images, as in this case, show areas of disturbed earth that represented mass graves, in the cases of Krstich, Popovich, and Ptolemy. The images also showed other items of interest, such as buildings, vehicles, and groups of prisoners. The admission of satellite imagery as evidence was controversial because the US refused to release information about how the images were acquired on national security grounds. They didn't want to disclose the location or the capability of satellites. This meant no one could arguably be certain about whether the images provided by the US were accurate, correct, or indeed real. And you still find these debates playing out today in online discourse around the ICTY. The images provided an interesting problem of authentication and verification, which continues to resonate in international criminal law. But it also resonates with the problem of AI accountability, because it shows the tribunal grappling with the problem of achieving certainty via transparency. So this looks like transparency, right? It shows us something that happened, where the mechanism by which transparency was achieved, so the details of the acquisition of these images, can't be verified, potentially destabilizing the certainty that it provides. So is it still a document if you don't know who wrote it, how they wrote it, or when they wrote it? Can it still provide certainty? So this looks like a document, but is it actually? It's not like the minutes of a meeting, is it? Because we don't know where it came from. And this usefully recalls the problem of only being able to get partial certainty about how AI decisions are made via only partial access to the interior documentation of AI decision-making. So the prosecution ended up using the concept of documents to incorporate the satellite imagery as evidence, and thus as an aid to transparency, certainty, and then accountability. So they weren't, of course, referring to the concept of documentality, which I've introduced earlier in this presentation, but I hope you can see that there's a very strong conceptual link here to the role of documents in providing that ultimate accountability and certainty. The images were incorporated as a type of evidence called documentary evidence, and that concept draws on existing common law practices. What it means is they can be evaluated as evidence on the same basis as paper documents, as a record of events. You can still contest them, but they're admitted as if they were real. And in addition, the imagery was incorporated into evidence as what's called a self-authenticating document. So the same thing could happen, for example, with a certified paper document or a paper document with a logo that could be self-authenticating as to its source. So if you certify a document as a justice of the peace, that's what you're doing when it's admitted into courts. You're allowing it to be admitted as a self-authenticating document. So the argument goes that if I submit a document on an ANU letterhead, you can reasonably assume in court that it's indeed an ANU document. So this decision to admit the satellite imagery as a self-authenticating document drew on legal traditions in Europe and the UK, but it was an entirely novel approach at the time. And it meant that these images provided a route to transparency as to what had occurred, and as a result to certainty and accountability. So this process suggests that assigning authenticity to epistemic elements, that's what a document is possible without further interrogation of those elements, although only if it's treated as a document in the context of the trial. So by contrast, for example, in a case before the Special Tribunal for Lebanon, the defence attempted to submit WikiLeaks documents as evidence, but they were ultimately deemed unverifiable by the Special Tribunal chamber, thus rendering them admissible. So the uncertainty as to their origin was too great to allow them as evidence, whereas documents from the US National Security Agency could, in this case, could be assumed as verified, even if they couldn't actually be verified. This shows that the existence of documents and the certainty, transparency, and accountability they can provide can be determined in relatively fluid ways by the organ of accountability itself, in this case, the tribunal, rather than conforming to an external standard of transparency and truthfulness from somewhere else, from our standards in bureaucracies, for example. This suggests that even in the high-stakes and highly uncertain area of international criminal law, self-authenticating evidence can be admitted because trusted sources can exist without interrogation of the methods by which information is created. This resonates with the problem of accountable AI. It appears that we can rely on documentation of events without knowing exactly how that documentation was produced. We simply have to trust that the document is what it says it is and insert it into an existing system of meaning and verification. So what does this mean for accountable AI? The limited analysis advanced in this presentation suggests at least 3 practices by which judgments are made under conditions of irresolvable technologically mediated uncertainty in international criminal law. So these 3 practices are corroboration, contestability, and authentication. And each of these offers lessons for actors who are searching for accountability in internationally oriented AI decision-making systems, especially in high-stakes contexts, such as resort to forced decision-making. So the concept of corroboration suggests that developing expertise and information from a range of sources can sufficiently reduce uncertainty, at least in the ICTY's view. This is reminiscent of current approaches in attributing cyber attacks, for example, where certainty is approached via corroboration and contestability rather than documentary certainty, which is unachievable. In the context of resort to forced decision-making, this suggests a role for multi-source corroboration of decision-making by technological systems. Contestability suggests that uncertainty can be sufficiently mitigated by debate about the relationship between evidence and fact. The experience of the ICTY suggests that facilitating contestability is a valuable and established way to reduce uncertainty, even if debate is not necessarily conducted under the auspices of entirely knowledgeable oversight regarding technology or scientific method. In the end, it doesn't matter how complex the system is. What matters is how we approach it. The judgments at the ICTY regarding forensic evidence were made by non-experts, for example, but certainty and thus accountability were still satisfactorily achieved. And approaching epistemic uncertainty through a lens that emphasises contestation, even in the absence of absolute expertise, reduces the temptation of technoscientism apparent in a black box approach to AI. In practical terms, for accountable AI, facilitating contestability, even within a single state's decision-making process, could facilitate the production of counterfactuals by competing systems, for example, reflecting ICTY debates about professional standing and expertise. Emphasising certainty and accountability in accountable AI could mean ensuring that information that is relevant to the relationship between the AI, the forum in which decisions are made, and accountability is generated and assessed by human decision makers. Contestability also raises the issue of private actors and private interests in that process of debate. The example of US satellite data being admitted as evidence and automatically authenticated despite defence objections shows that actors outside the court's jurisdiction can potentially limit the court's access to contestability if they choose to. They didn't in this case, potentially they can. And you see this all the time in debates around accountable AI. So you'll see this reflects work by critical scholars of AI who argue that the political economy of AI limits our capacity to hold it accountable because the corporate origin of AI means trade secrets can be invoked even if the technical barriers are broached. So even if we could know what was going on, the companies that own the AI will claim that this is proprietary material and not allow us access. So defence acting for tech companies, for example, will preclude access to AI models on the basis of corporate IP, or will simply argue that the complexity of the models means that they can't be explained in a court of law. It's like, oh, sorry, can't tell you, it's out. Finally, the treatment of evidence in international criminal law suggests a role for authentication. Authentication is the process whereby information is admitted as documentary evidence based on decisions about the reliability of its sourcing. In the context of AI, this could refer to special attention paid to the custodial chain of training data, for example. And indeed, this is a live debate in international criminal law in the context of evidence lockers and social media data, as in the case of the Gambia versus Facebook, which is a current course of the ICJ, which I'm happy to talk about. Adopting and adapting principles of corroboration, contestability, and authentication from international criminal law to the search for accountable AI is a thick, qualitative approach to accountable AI that adopts model-centric approaches to problems of explainability and accountability. This builds on Ashley Deek's work. Ashley Deeks was another scholar involved in this project who's produced some really important work on this issue in the national security space. So she calls for the adoption of common law tools in building accountable AI, using tools that already exist. And this is in contrast to the decompositional model, which I outlined in my first slide, which searches for solutions within the model itself. And this has dominated certain strands of scholarship and policymaking on AI governance. The lessons for evidentiary approaches at the ICTY help to build a case for a socially situated AI, and thus accountable AI, rather than the document-driven, algorithmically focused approach to accountability offered by a decompositional model. And importantly, this is my final point, adopting this thick, socially and indeed historically centred approach to AI accountability allows us to reclaim responsibility from tech companies and the engineers they employ. It allows us to acknowledge that accountability is socially constructed and to situate AI accountability in a context that makes sense to us as a community, despite the black box. Thank you.